All right, we are on the record for ERD case number CR2018-01462 with an EEOC case number of 26G 2018-00941C. The complainant is Mario Sharp. The respondent is the Cannery Market LLC. I'm Administrative Law Judge Stephanie Brown. It is Thursday, March 25th, 2021 at approximately 10:30 a.m. We're here for a hearing on the limited issue relating to whether or not the complainant received notice that a post office was attempting to deliver a certified letter to Mr. Sharp from the Equal Rights Division. And that follows from a pretty lengthy history of the case. On May 22nd, 2018, Mr. Sharp filed a discrimination complaint under the Wisconsin Fair Employment Law against the Cannery. And on December 6th of 2018, an investigator for the Equal Rights Division issued an initial determination finding probable cause of discrimination, or I should say probable cause to believe that the respondent had violated the Wisconsin Fair Employment Law by refusing to reasonably accommodate a disability, discriminating against the complainant in terms or conditions of employment because of disability, and terminating the employment of the complainant because of disability. The case, based on that initial determination, was certified to a hearing on the merits of the complaint and assigned to me to hold a hearing on the merits of the complaint. On January 10th of 2019, I had our office schedule a pre-hearing telephone conference with the parties. That conference was scheduled for February 11th, 2019 at 11 a.m. The parties did appear in that initial pre-hearing conference and agreed to engage in the mediation process. And so the file was assigned to a different administrative law judge for mediation. The parties were unable to resolve the case in mediation, so the file was returned to me for the hearing on the merits. And on August 16th of 2019, I again had our staff send out a notice of pre-hearing telephone conference to the parties, scheduling a telephone conference for Thursday, September 5th, 2019 at 1 p.m. On that day and time, I should say in that notice, it provided a telephone number and a passcode for the parties to connect via a conference call to discuss scheduling the case for hearing, as well as other issues noted in the notice. On September 5th of 2019, I connected to the conference call as well as the respondent's then attorney of record. We waited until 1:10 p.m. and the complainant did not call in. So on September 12th of 2019, I sent a letter to the complainant by regular mail as well as certified mail, asking the complainant to contact me and let me know if he intended to appear and proceed with the case. The letter provided that he needed to respond within 20 calendar days, and if he failed to respond within that time period, his case would be dismissed with prejudice for failure to respond pursuant to section 111.39 parentheses 3 of the Wisconsin statutes. I did not receive a response from the complainant within that 20-day period. In addition to that letter, there was a notice also provided on U.S. Equal Employment Opportunity Commission letterhead giving the complainant 30 days to respond pursuant to their federal rules. And again, the case, as I noted, it was cross-filed with the EEOC. Waiting that period of time, we did receive back from the Postal Service the copy of the certified letter showing that it had not been claimed. However, we did not receive back a copy of the letter that was sent to the complainant by regular mail. On October 28th of 2019, the complainant filed a petition for review with the Labor Industry Review Commission. In there, he noted that he did not receive the mail previous to this and wanted to have a chance to respond to it. After reviewing the evidence on March 30th of 2020, the Labor Industry and Review Commission issued its decision setting aside my decision to dismiss the case and remanded the case back to the Equal Rights Division to hold a hearing to give the complainant an opportunity to establish that he did not receive notice that the post office was attempting to deliver the division certified letter. And if he met that burden, then the case would go on to a hearing on the merits. And so that is why we're here today, again, for that limited issue of just giving the complainant an opportunity to present evidence as to whether or not he received notice that the Postal Service was attempting to deliver a certified letter to him. Prior to today, I had numerous communications with the parties by letter. That included starting on, I just want to, sorry, I'm going to take a second right here. I got an email. I just wanted to make sure it wasn't the complainant communicating with us. And so it's not. But again, on January 8th of 2021, I sent Mr. Sharp and again the respondent's attorney of record at that time, Patrick Coffey, a letter just explaining to them that I had received the Labor and Industry Review Commission's decision, that I was attempting to schedule a hearing to have on that limited issue, that the Labor Industry Review Commission had remanded the case back to me. I had noted that we had stopped doing in-person hearings because of the COVID-19 pandemic, had explained that we have been doing hearings using WebEx video conferencing, and wanted to schedule a hearing via WebEx for the parties, and provided dates in February and March that I was available for the hearing. In addition, I had provided a copy of the Labor Industry Review Commission's decision with that letter. I had also included copies of some documents that I had noted the parties, or I should say I had provided notice to the parties that we may use at the hearing here today. That included a copy of the certified letter that was returned to our division as being unclaimed, as well as a USPS tracking information that was printed off the computer from our division, showing the tracking history of that certified letter. In that letter, I had asked the parties to provide me with their availability for hearing, and I asked them to do that by January 22nd of 2021. The respondent provided its availability. On January 27th, I was notified that the attorney Coffey was no longer representing the respondent, but instead that attorney LaCrosse was going to be representing the respondent. And so on January 29th, I sent an email to attorney LaCrosse, attorney Coffey, and Mr. Sharp, letting them know, first of all, that I was updating our records to make sure that we had the right attorney for the respondent noted. And then again, just asking the parties to provide me with their availability for the hearing. And again, I gave dates this time in March and April that I was available, and asked the parties to give me their availability by February 5th. After sending that email on January 29th, on February 2nd, I received a communication from attorney LaCroix with her availability. And on February 3rd, I had sent out a letter to Mr. Sharp by regular mail. First of all, because I had received confirmation the prior day that the email I had sent on January 29th did not go through to him. And so in addition to including a copy of that email and the attachments included in that email, which was the January 8th letter and the documents referenced in that January 8th letter, I had sent him, like I said, this February 3rd letter, again, asking him to get in contact with me and let me know what his availability was for hearing. And at that point, I had limited to 3 days based on attorney LaCrosse's availability, March 11th, March 18th, and March 25th. And I again gave Mr. Sharp a deadline of February 12th of 2021 to let me know what his availability was. And I noted that if I did not receive a response from him by that date, I would pick one of those 3 dates for the hearing. And so I did not hear from him by that date. And so on February 17th of 2021, I sent a letter to Mr. Sharp and attorney LaCrosse, letting them know that I was going to schedule the hearing on March 25th, 2021, beginning at 10 a.m. I noted in there that they would be receiving a notice in the mail confirming the date and time for the hearing. And then in early March of 2021, I would be sending a WebEx invite to them, which included a join meeting button to let them connect to the hearing on today's date. I included links to test out the WebEx to make sure that parties could connect. I also included a link to our online instructions about the ERD's online hearings. I again included copies of the USPS tracking records about the certified letter and the copy of the return certified letter. Again, noting that these may be records and documents that I would use at the hearing here today. I reminded the parties about the requirement that they provide witness lists and any copies of hearing exhibits per our rules, and that needed to be done by March 15th of 2021. I want to make sure then on February 18th of 2021, the actual notice of hearing on remand from the Labor and Industry Review Commission was sent to the parties. Again, noticing that this case would be heard on March 25th of 2021 at 10 a.m. It again noted in there that you would receive invitations by email and to accept the meeting and click on the send response. And then also noted save your email so you can click on join the meeting at the scheduled time. On March 11th, I believe, let me just double check that. Yes, March 11th of 2021, I sent out the WebEx invite to Mr. Sharp's last email address as well as Attorney LaCrosse. Again, noting that the hearing was going to be on March 25th at 10 a.m., reminding the parties that if they had witnesses and exhibits that they wanted to use, that they needed to submit that information by March 25th. They explained what would happen when they tried to connect and how they would be placed in the lobby until I allowed them into the hearing room. I noted in there that I had provided them with copies of the 2 documents that may be used at the hearing and asked that if you didn't receive those copies to let me know, and I would provide additional copies to you. I provided my contact information in the form of my signature block. And I also noted that if there was any problems connecting to WebEx on March 25th, that the party should give me a call at 414-897-4974. That is my work cell number. I just checked my phone. Again, I haven't received any communications from Mr. Sharp today, either by phone or email. I also want to note that at no time did any of the letters that I sent to Mr. Sharp beginning in January of this year, nor has the hearing notice ever been returned to us. So I'm assuming that he did receive our mail. Like I said, I've received no communications from him even prior to today that there was going to be any issue or he didn't have the ability to connect using WebEx. And again, no communications from him so far this morning, letting me know that he has any problems connecting or anything like that. And so it is now 10:45 a.m. after I have gone through the lengthy history. And he has not connected. And so I guess in all of that, Attorney LaCroix, I never asked you to make your appearance for the record. So if you would just state that at this point, please, so we know who you are.
Yes, thank you. Attorney LaCrosse appearing on behalf of the Cannery Market LLC.
All right. And so, as I said to you prior to going on the record, we are required to give parties at least 30 minutes to appear. And so, like I said, it's now 10:45. He has not appeared. And so I think we can just assume that he is not going to appear today for the hearing. I do have to wait 10 days just to see if I get any communications from him explaining why he did not appear. And as we sit here today, I'm tempted to make one last attempt to communicate with him by mail just to make sure, because I don't want to have happen what happened previously, that I dismiss the case and then he appeals to LIRC and they again remand it. And so I'm going to give him the 10 days to make sure that if he communicates with me, I'll have to decide whether or not he had good cause for not appearing. But I may, like I said, just send out one more letter to him, just asking him to let me know if he has any intentions of proceeding with the case. And If I don't hear from him by then, again, dismissing it. And if I do that, Attorney LaCrosse, I will copy you on that as well. Just again, make sure that you have that. But like I said, my biggest concern is I just don't want to have happen what's happened already, that,
Mm.
I dismiss and then I get a reason from him as to, I didn't get the mail. But as I said, there's been no evidence on my part up to this point that any mail that we have sent to him has been returned to us, other than that unclaimed certified letter. And like I said, when we sent that certified letter, we sent a regular copy by US mail, and that was not returned to us. So, the presumption is that if you send mail, it's received,
Hmm.
and there's been nothing returned to us to suggest that he's not getting the mail. There's been nothing, he hasn't communicated to us that the address we have on file for him is incorrect. So I can only assume that he has received the mail and just hasn't responded and has chosen not to participate. Um, is there anything, Attorney LaCrosse, you wanted to put on the record before I kind of close the hearing for today?
No, I think you covered everything. Thank
All
you.
right. Well, thank you for calling in this morning. And like I said, if I hear from him, I'll get in contact with you. If I do
Okay.
decide to send another letter to him, I will send a copy to you as well. And then we'll just kind of wait to see if we hear anything else from him.
Okay.
And if I don't, after both that 10-day period as well as the letter, then I'll go ahead and dismiss the case and you'll receive a copy of that notice as well.
Okay. Perfect.
All right. Well, thank you
Okay.
so much for taking
Thank
your
you.
time today to connect,
Yes.
and have a good rest of your day. Take care.
You too. Thank you.
Thank
Bye
you.
bye.
Bye.